Hi, I'm here to talk briefly about race equity and the role it plays in our current work, as well as our goals for the future. I'm going to start with some definitions to be sure we all understand the terminology we're going to use. First, what is race equity? Many people may understand the terms separately, but may not understand the concept as a whole. Equity is not equality, but rather fairness. Racial equity is the condition that would be achieved if one's racial identity no longer predicted, in a statistical sense, how one fares. Race equity is a process and a goal. Second, what does person of color, or POC, mean? In this presentation, we are defining person of color, or POC, as someone who is not white. Next, what is institutional racism? Institutional racism refers to the ways in which institutional policies and practices create different outcomes for different racial groups, even if those policies are not racially discriminatory on their face. Every day, our clients face policies and structures that were built by white people, are maintained by white people, and were designed to benefit white people. People of color make up 41% of Georgia's population, but account for 89.89% of Georgians in poverty. Despite federal and state protections in the law based on race, the law is clearly failing to create equitable outcomes for people of color. Let's review a few of the legal protections based on race. The 14th Amendment of the U.S. Constitution and Section 1 of the Georgia Constitution provide due process protections and equal protection under the law. The Civil Rights Act of 1964 banned unequal application of voter registration requirements, racial segregation in schools and public accommodations, and employment discrimination based on race. Title VI of the Civil Rights Act of 1964 prohibits racial discrimination by programs or activities receiving federal financial assistance. And Title VII of the Civil Rights Act and the Equal Employment Opportunity Act of 1972 protects employees and job applicants from racial discrimination. Georgia's Fair Employment Practices Act was designed to safeguard individuals from discrimination in public employment, meaning public agencies or local, state, and federal governments. Notably, these laws do not protect the majority of individuals who work in the private sector. The Federal Fair Housing Act and Georgia's Fair Housing Act protect people from discrimination on the basis of race when they are renting or buying a home, getting a mortgage, seeking housing assistance, or engaging in other housing-related activities. The Equal Credit Opportunity Act prohibits creditors from discriminating against credit applicants on the basis of race or because the applicant receives income from a public assistance program. Georgia has a similar legal protection called the Georgia Fair Lending Act. However, this law was weakened less than a year after it was enacted. Even with some race-based legal protections, our clients are still treated unfairly based on their race. And this disparate treatment has measurable consequences for their mental and material well-being. Here are just a few examples. In the world of public benefits, Georgia's harsh rules and disinvestment from cash aid have severely impacted Black families, who make up 70% of TANF recipients in Georgia. Georgia has the third highest percentage of Black residents in the nation, but TANF only reaches 5 out of every 100 families with children in poverty. In the world of domestic violence, women of color who survive domestic violence are less likely to be believed by law enforcement and judges than white women, and that law enforcement and judges are overwhelmingly white, meaning that they face a system that is not only not supportive of them, but in some cases is actively endangering them. For our clients who are people of color, their race is often compounding the issues that bring them to us. Georgia Legal Services Program recognizes that it is imperative that our work center race equity, and we are focusing resources on cases where we can combat racism, both individual and institutional, to assist clients more holistically. Georgia Legal Services Program's Savannah Reentry Project is a specially funded project that enables GLSP's Savannah office to assist formerly incarcerated people with issues involving employment, public benefits, child support, housing, criminal record expungement, obtaining government-issued identification, healthcare, education, and substance abuse. We have the second highest incarceration rate in the country, with 1 in 2 Georgians having a criminal record. That means half of the population. Between 1983 and 2015, there was a 329% increase in the number of people incarcerated in Georgia. In 2017, Black Georgians made up 32% of the state population, but 51% of the jail population and 60% of the prison population. This racial disparity not only affects people's freedom while they're in jail, but it continues after their release. Employment has been found to be the #1 predictor of recidivism. That is, people with jobs are less likely to re-offend and end up back in jail. Reducing recidivism by even 1% saves $7 million in taxpayer money. Lisa will be discussing employment more in a moment. Another way to reduce recidivism is to ensure formerly incarcerated people have stable housing. Housing assistance programs are essential for low-income households, but restrictions regarding a history of alcohol or drug abuse or criminal record can keep some families from this assistance. Public housing authorities have a lot of discretion in this area in terms of how far back they can look for a criminal record, whether arrests without convictions will be considered, and whether they will consider the seriousness of the criminal charge and any mitigating circumstances. For example, the Winder Housing Authority and Flint Area Consolidated Housing Authority in Montezuma, Georgia, define criminal activity that can exclude a family's admission to public housing as only 1 arrest in 5 years, even if the applicant was never found guilty. Some housing authorities, including some in Fulton County, Savannah, and Soperton, have zero tolerance rules and use their discretion to automatically deny admission to applicants with felony convictions. Given such discretion afforded to housing authorities and the disproportionate policing of minority communities, it's no surprise that racially disparate outcomes result. At Georgia Legal Services, we help people who are not convicted restrict and seal their criminal records and obtain pardons where they are eligible, to try to remove this barrier to livelihood and housing that millions of Georgians currently face. GLSP has also partnered with Advocates for Restorative Community in Savannah to create a proposed fair chance housing ordinance with proposed procedures for considering arrests, convictions, and similar barriers in housing decisions. Among other things, this proposal would limit housing providers' ability to inquire about arrests that did not result in convictions and provide people in Savannah with the opportunity to provide evidence about their individual circumstances and mitigating factors. The proposal also includes the creation of new positions to facilitate appeals of adverse housing decisions and to educate both tenants, landlords, and the larger community about the legal protections for tenants. We have also developed a survey to collect more data on how Georgians' criminal records are affecting their access to stable housing, and have partnered with Advocates for Restorative Community in Savannah and Georgia Tech to process and synthesize this data as a tool to advocate for fairer housing practices. As I stated earlier, the Fair Housing Act protects people from discrimination on the basis of race. At Georgia Legal Services Program, we assist clients in federal and private housing who are discriminated against based on their race. One aspect of this is representing clients whose criminal record is used as a pretense to discriminate against them. Now, discrimination in housing does not always mean simply refusing to rent or sell a home to a person of color. It can also look like falsely denying that a house is available for inspection, sale, or rent, offering different terms, conditions, or privileges for certain people, intimidating, interfering with, or coercing someone to prevent them from buying or leasing a dwelling, discrimination in advertising, discrimination through financing or broker services, steering of clients by certain real estate agents to or from certain neighborhoods, and of tenants by landlords to or from certain areas of the complex. Home ownership can provide stability and the opportunity to build wealth, as well as greater economic vitality for the community. However, federal housing policies and discriminatory mortgage lending practices, along with continuing impediments to access, have had significant impacts on home ownership rates for people of color, particularly Black and Hispanic populations. In 2017, the U.S. Census Bureau reported a 21.6 percentage point gap in the home ownership rate between white and Black households nationwide. In the U.S. in 2019, there were 4,757 complaints processed by fair housing organizations, HUD, Fair Housing Assistance Program agencies, and the Department of Justice. And we expect that that number is significantly lower than the actual number of incidents of racial discrimination in housing. GLSP recognizes that access to fair, stable housing reduces inequity. Our attorneys assist clients with bringing these fair housing complaints and holding housing providers, management companies, lenders, homeowners associations, insurance companies, and others accountable. For our people of color clients in particular, understanding their rights and protections and having representation by a GLSP attorney or a pro bono attorney trained by GLSP can mean having a stable place to call home.
Georgia Legal Services Program engages in robust representation of the most vulnerable populations in Georgia. As a part of that representation, we collect and review data on the populations affected by inequitable treatment. We use those data to assist us when representing clients. Two of those areas where we use data to assist with representing populations affected by inequitable treatment are in racial disparities in disaster relief and the high cost of credit for people of color. Chasing the Storm, an analysis of the effects, impact, and implications of opportunistic environmental gentrification, is a policy paper and analysis written by our former summer intern, Kawan Rowland, a rising 1L at Howard University School of Law. The paper discusses the disparate assistance provided by the Federal Emergency Management Agency, or FEMA, after a disaster to Black and non-white Americans. An earthquake can destroy the homes of the rich and poor alike. A storm can flood property regardless of the owner's net worth. A tornado can blow away treasured personal possessions, no matter how many or few one may have. Nature's destructive potential is neutral, but discrimination exists in the way that destruction is remediated. Viewed in tandem with the fact that low socioeconomic status trends with an increased likelihood of living in an area at risk for a natural disaster, one can begin to understand the causes of the gap in disaster aid. Communities with less wealth, including communities of color, often have lower property values, which gives a smaller window before repairs would cost more than a home's value. The paper analyzes this phenomenon that we describe as opportunistic environmental gentrification, and it discusses the issue in relation to Georgia residents. For example, Georgia's wealthiest zip code, 31561 in Sea Island, lost every single one of its Black residents following Hurricane Matthew in 2016. Opportunistic environmental gentrification is most prevalent in communities that are already majority white with a significantly outsized Black population. OEG combines nature's fury and society's elitism in a way that is too complex to combat simply with legislation or knowledge of the issue. Black and non-white Americans are more likely to be denied funding from FEMA, and when they do receive funding, it is between 5 to 10% less than their white counterparts. FEMA determines the appropriate types of housing assistance for which an individual or household may be eligible based on disaster-caused loss, access to life-sustaining services, cost-effectiveness, and other factors. 11% of Blacks are denied FEMA relief for no given reason, while only 4% of whites are denied for no given reason. Furthermore, government aid is hindered when heirs' property is at stake. FEMA requires proof that the applicant is a homeowner. Heirs' property that is not probated lacks the documentation of the current living owner, which means that they will not receive funding or that they will experience significant delays and hardships in getting the aid. This disparate treatment emanates from both the government and private entities. For example, utility companies showed a bias in Austin after the most recent Texas freeze. Maintaining housing and shelter is a top priority for Georgia Legal Services program, so it is critical for us to know the landscape of the type of issues, including distribution of disaster relief, that disparately impact our client population. Providing access to disaster relief and educating clients about federal and state disaster relief programs about which they may not have been aware is one way that GLSP impacts our clients. The paper suggests that GLSP needs to work with property owners who are within a group that are most likely to be permanently displaced after a natural disaster and assist them with preparing for the inevitable. For post-disaster work, GLSP advocates on behalf of clients with government agencies, including completing applications for FEMA assistance. The Black Tax, where race, poverty, and credit collide, is a policy paper and analysis written by our former summer intern, Tyra Boos, a rising third-year law student at North Carolina Central School of Law. This paper addresses the issues surrounding consumer credit, poverty, and race. The connection between credit lending and race shows that discrimination is present and affects minorities at a high rate. The paper analyzes the cycle of consumer credit utilized by most Americans, with which many of us are familiar: credit worthiness on the basis of a credit score, approval or denial of credit, and completion of the loan, agreement, or default. The Federal Trade Commission defines consumer credit as a system that allows consumers to borrow money or incur debt and defer repayment of that money over time. And that's defined in consumer credit law and practice in the U.S. The FTC continues to state that access to credit is a valuable benefit which a person should protect and manage wisely. Perhaps unsurprisingly, there is a relationship between race and access to consumer credit. Research shows that credit may be a privilege as opposed to being freely offered to all. Although access to credit depends on previous credit history, it is not as objective as it may sound. We think that those with good credit histories should have more access and ease to borrowing money from lenders, as well as an ability to borrow with better terms. And we understand that consumers with poor credit histories are unable to obtain necessities such as housing, transportation, or even access to a credit card. In practice, people who have steady incomes with lower debt to income ratios will normally have a good credit report. It turns out that steady income is intricately related to other factors, including race. Wealth Simple magazine reported research at Yale and Northwestern that estimated that Black families in America hold only $5.04 for every $100 that a white family holds. Out of the 50 states, Georgia was ranked 37th for overall poverty, 34th for affordable housing, 43rd for unemployment insurance, and 50th for health insurance coverage. The overall rate of poverty within the United States is 12.3%, excluding data from Puerto Rico. The race and ethnicity with the highest rate of poverty is at an astounding rate of 24.2%, and those people are the American Indian and Native Alaskan group. Second, with a difference of only 3%, are Blacks or African Americans. Such data tend to show that minorities are susceptible and experience poverty at a greater rate than their white counterparts. Black borrowers were more likely to be saddled with high-cost mortgages when buying a home in 2019, reflecting the persistence of racial discrimination that is only slowly improving. Recent research from the Urban Institute showed credit scores are significantly lower in St. Louis's neighborhoods of color than in mostly white neighborhoods. And there is hidden discrimination in lending. Despite prohibitions against discriminating against borrowers due to their race, credit is very costly for people of color in the United States. The U.S. Census Bureau estimated Black homeownership to be at 41.7% in the third quarter of 2018. That's about the same rate as it was in 1970. An analysis by the Center for Investigative Reporting about mortgage lending, and they analyzed 31 million mortgage application records, found that African Americans and Latinos were much more likely to be denied conventional mortgage loans than their white American counterparts, even after controlling for factors like an applicant's income, the amount of the loan, debt-to-income ratio, type of lender, and even the neighborhood where the property is located. One study by the National Bureau of Economic Research found that African Americans are 105% more likely and Latinos are 78% more likely than white Americans to have a high-cost home loan. An article published by New York University's Law Review noted that credit reports create vicious cycles for debtors. One such cycle occurs when credit reports are used for extending loans to consumers. Although such reports may provide background information that may predict whether one will pay back a loan, they also indicate economic instability. Clearly, individuals in economically unstable positions are subject to the vicious cycle that requires higher interest rates, otherwise known as predatory loans, or refusals by creditors to extend credit, denials. Predatory loans are loans that take advantage of consumers through acts of deceit, and predatory lenders often prey on consumers with low credit scores, offering discounted rates or deferred payment plans to entice those consumers. Most of the targets and victims are low income, so they are less likely to have the knowledge of how credit works or to have someone advising them. As such, lenders will intentionally engage in transactions with low-income consumers because they are aware that the lack of knowledge and experience held by these consumers affects their understanding of how credit works and how that credit will affect them in the future. Similarly, an employer may check an applicant's credit during the hiring process. Such checks are permitted under the Fair Credit Reporting Act. Credit checks are often conducted as a form of a background check. For some jobs, an individual may lose an opportunity due to their credit report or outstanding debts. For those in poverty or who are classified as low income, a missed job opportunity due to a credit score continues this vicious cycle. An inability to build wealth individually or on a communal basis negatively affects our clients. Our clients oftentimes are not educated about credit and debt, but we do help. Here are some examples. A client who was at 66% of the federal poverty rate was sued by a major auto rental company for a total loss. Georgia Legal Services Program settled that case without any negative credit reporting and an agreement for that company to cease all collection efforts against the client. Another client who was at 126% of the federal poverty rate filed an affirmative suit against a national for-profit university for its unlawful debt collection practices. Georgia Legal Services Program settled that case on behalf of the client with a cash payment to her. And finally, we had a client who was at 56% of the federal poverty rate who had financed windows for her home in a door-to-door sale. The lender engaged in predatory lending practices and refused to honor a Federal Trade Commission notice. And in that case, Georgia Legal Services Program settled the matter through a cancellation of the alleged debt, an agreement not to report any negative item on her credit report, and an agreement to cease all collection efforts. Our focus on predatory loans, improvidently extended credit, and illegal denials for requests for credit for Georgia Legal Services Program's clients of color means that we are providing equitable access to credit in vulnerable populations. Finding and proving that discrimination has occurred is difficult, as lenders are able to hide discrimination under the guise of a credit score or unpaid bills. In addition to lawsuits against predatory lenders that fight garnishments and unlawful debt collection practices, Georgia Legal Services Program educates its clients on the use of credit and their rights as borrowers. We are ensuring that credit reports contain accurate information and that they are used only for legal purposes.
I'll briefly discuss two more areas where we have identified trends and issues of racial justice as part of a holistic approach to representation: education and employment. Education. Georgia data and our experience show that children of color are more likely to be disciplined and given long-term suspension or expulsion. It's very obvious when students do the same act and get different punishment, with students of color getting more harsh treatment. Our review of our education advocacy since 2018 reveals disturbing trends. A significant portion of GLSP's Black clients facing school discipline have special education needs that have not been met, and the school instead seeks to discipline those students. As you heard during the education segment, our attorneys frequently must advocate and often litigate to force school districts to recognize and serve their Black students' disabilities and not punish students for conduct related to their disabilities. With our knowledge of this trend, we can challenge relevant policies and structures. Is it a neutral policy? Is it structural racism? Our advocacy will enable more students to stay in school and receive the appropriate education. Getting a positive result for our clients leads to a sense of fairness for all students involved and educates teachers and administrators on more equitable treatment of students. When we file Office of Civil Rights complaints, including under the Civil Rights Act of 1964, with federal agencies to raise discrimination and disparate impact in education policies and their application to make change for our client, those changes aid other students too. Through community events, including online, we will continue to inform students, their families, and interested community members about education rights. The pandemic has highlighted inequities that have existed for generations that we should address to meet our mission. National numbers and in our unemployment benefits cases accepted during the pandemic reveal that people of color were disproportionately impacted by layoffs and cut hours, so that unemployment benefits were critical. We opened 59% more unemployment cases for people of color than whites for the period of March 2020 through June 2021. At hearings, we raised the facts of discriminatory treatment to explain a termination or a quit for a client who faced discrimination on the job. The hundreds of unemployment cases for clients during this period gave us the opportunity to see the conditions of their pre-pandemic employment that included possible violations of the Civil Rights Act of 1964 for retaliation, hostile work environment, and other forms of discrimination. We have also seen women, mainly of color, not offered Family Medical Leave Act leave, and then they lose their jobs. Many were unaware of the legal protections and suffered as a result. Not only did we advise clients of color of these federal rights, this insight will remind us to provide information to clients who face discrimination other than based on race. This experience demonstrates the need for further employment representation in rural Georgia. Educating clients about federal legal protections and the relevant federal agency should help reduce on-the-job discrimination And our representation at hearings are critical because it takes representation at a hearing to win most unemployment cases in Georgia. You've heard about some of our racial justice work and that the quest for racial equity permeates our advocacy. Our racial justice advocacy is consistent with our mission of providing equal access to justice and opportunities out of poverty. As you see on the slide, issues of credit, education, health, income, jobs, housing, family, and public benefits demand our attention to achieve racial equity. During the pandemic, we have seen the intensity of stressors on all of our clients, but stressors have disproportionately impacted people of color. Our statewide vantage point gives us the ability to see patterns, trends, as in our special education practice, and structures that harm our clients. We represent clients to challenge injustices and educate them about their legal rights, and be a lifeline in communities, especially in rural ones, to knowledge and other legal assistance. At 50 and Forward, we have the knowledge, opportunity, including on our race equity team, and responsibility to educate clients and communities of legal rights to achieve racial equity. For these subject areas, if we cannot represent the client in the claim or forum, we try to connect them with other legal representation through state and national nonprofit law firms, Georgia private attorneys, or the relevant federal agency. The Biden administration's equity mandates on federal agencies give new life to federal civil rights protections, but those rights are illusory if Georgians don't know about them. We are guided by what Dr. King wrote in his letter from the Birmingham jail, quote, "Injustice anywhere is a threat to justice everywhere." Let's get back to work. There's much work to do.